and welcome to a Newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Picture a quiet residential street, neatly trimmed lawns and a tiny strip of grass, barely 8 feet wide. Harmless until a garden gnome appears and suddenly that little patch of lawn becomes the centre of a legal dispute. Welcome to the Unpacking the Case podcast by David Jones Bold. In today's episode, we're digging into a fascinating property dispute that's been making headlines, Dobson Anor and Unsted from March 2026, a decision from the Upper Tribunal. This case is about adverse possession, sometimes known as squatters' rights. That's the idea that somebody can claim land as their own if they've treated it like their property for long enough. In this dispute, a couple argued that years of mowing, tending and cultivating a narrow strip of grass meant it had effectively become part of their garden. Their neighbour disagreed and strategically placed a garden gnome, which added fuel to the fire. The story quickly captured the media's attention, with headlines about a millionaire couple using squatters' rights to win ownership over 8 feet of lawn. Behind the quirky details, though, lies a serious legal question about possession, evidence, and how courts decide when use of land becomes ownership. In this episode, we'll unpack what actually happened in this case and why the Upper Tribunal wasn't convinced by claims that herbs like clover had been planted years earlier, and what this case can tell us about adverse possession, especially when it comes to unregistered land. Hello, Richard.
Hello, Lizzie.
How are you?
Oh, I'm okay.
Oh, Jinx Padlock. Yeah, I'm good as well. So we're here to talk about a newsworthy case. It was in the news last week, and it's an Upper Tribunal decision from the 2nd of March called Dobson Anor and Unsted. And it's about something we talk about quite a lot in the webinars and podcasts, which is adverse possession in registered land. So do you want to start with giving us some background facts to the case?
Yes, Lizzie. Yeah, yet another adverse possession case. There seems to be a lot this last year or so. Starting off with, there's Clover and Naga. We did a podcast on it 2024, then that Brown and Ridley Supreme Court case from the end of February last year, and quite a lot of others. It's Dobson and another is Mr. Pleming, Pleming. And as you mentioned, it was in the news. It was certainly in the Telegraph, and it was on the BBC and a few other places besides last week. It's amazing that everything happening in the world at the moment, and this adverse possession case from Dorking gets to be a national news story. But anyway, I'm giving you a place anyway. It was Westcott Hill in Dorking. And originally, the two properties were in common ownership until 1994, when there was a conveyance of these two separate properties, number 29 and number 27. And the conveyance from 1994 obviously stated where the boundaries were. But it seems to be, it was a strange sort of setup. You're able to see from the news articles, sort of what the layout was. Number 29 had an easement of access across number 27's land. They got shared access. But it seems that the other side of and they got open plan lawns going down to the highway. And the other side of the access way, which is again in number 27's title, was a piece of land which was 1 metre by 2.3 metres. So a very small piece of land, which if you looked at the photos and the likes, it would look as if it was in the land of 29, but it was actually within 27, but no one seemed to realise this fact. And two people bought the two properties, including Mr. Curran, who bought number 29. And he seems to have sold on to a Mr. Hewitson in 2002. And eventually the number 29 ended up in September, I think it was, of 2009, in the hands of Dobson and Pleming, this couple. They always assumed as though it was their land, originally, Curran seems to have been sort of mowing the grass, and he mowed this piece of land as well at the same time. At a later stage, when Hewitson became involved, they were doing things like putting bins on this little piece of land. And before the Dobson and Fleming bought the land, they'd rented out number 27 for a year and then bought number 29. And they've been told by Hewitson, this is where you put the bins and this is where the neighbours put their bins, and we sort of mow the land and the likes. So that's what they were doing. And they sort of progressively, as time went on, it seems that the owners of number 27, who seemed to rent out the property all the time, didn't take objection to this and didn't tidy the land or assert any authority over the land themselves. Then what happens is sort of typical creeping sort of claim for adverse possession. They never fenced off the land. The tribunal sort of said that it'd be in Congress, it wouldn't look right to be fenced off. But they did things like they planted herbs originally in clover. Seems to be a big discussion about clover. And they tidied up the land. They raked the leaves off this little piece of land and so on. And eventually, they seem to have put a board, number 29 sort of board in this corner of the land, and let their children play on the land and planted wild flowers and changed the topsoil and so on. But in August of 2022, the Unsteds purchased number 27 and seemed to have taken objection, found out that this looks like it should be our land, and so they pulled up all the wild flowers and put a garden gnome in their place. And as you can imagine, that's going to cause litigation.
Yeah, I'm sure garden gnomes are responsible for lots of these things across the country.
Especially in Dorking.
Yeah.
But the Dobsons put in a claim for adverse possession. It's been a registered title since its inception of these two properties back in 1994. So it's all about claiming adverse possession in registered land, but also what you need for claiming adverse possession generally. So shall I tell you a little bit about recap you on adverse possession?
Yes, please do.
Well, firstly, if it's registered land and your claim arises from October the 13th, 2003, when the 2002 Land Registration Act came to us, do you know why that was the date it came in, Lizzie?
No, please tell us.
I mentioned it before in courses. It was the 50th anniversary of the then Chief Land Registrar. It was to bring in, the piece of legislation to celebrate his 50th birthday. Don't ask me how I know that. But anyway, if it's a registered land claim, well, we're basically claiming up to Schedule 6, Paragraph 5 of the Land Registration Act of 2002, which requires there to be some adjacent land. There was some adjacent land. There's been no exact determination of the boundaries by the Land Registry under Section 60 of the Land Registration Act. There's a general boundaries rule. There's never been an exact determination. The land has to have been registered for at least a year before the application, but that was clearly the case. But the other requirement is that there's a reasonable mistake as to boundaries. And it was held at the first tier tribunal that there was a reasonable mistake as to boundaries. They genuinely, and you can see from the layout of the land, if you see the photos and the likes, which you can't see on the podcast, if you just lived to this land, you'd assume it was part of 29. They were going to appeal that, but they dropped that part, on appeal. So there was no question about Schedule 6, Paragraph 5 applying, that there was a reasonable mistake as to boundary. So it was all about what you need for a claim of adverse possession. And as you remember, Lizzie, you need a corpus possessionis and an animus possidendi. Do you remember that?
Absolutely. Couldn't have said it better myself.
You need a factual possession and an intention to possess the land. And a lot of people think of fencing as being the be-all and end-all. They didn't make much of fencing because they said that fencing wouldn't look right on this. But they quoted some of the classic cases. They quoted Pyon v. Graham from 2002, House of Lords case, but didn't really go into that in terms of what you need for adverse possession. They quoted a case from 1977 called Powell and McFarlane that said if it's just sort of everyday, sort of tidying up land and maintaining existing fences, under facts and they were cutting down Christmas trees, as I recollect, on this land and grazing animals on the land. That wasn't enough for adverse possession, but it all depends on what use the land can be made of. There was a case called Hounslow Borough Council and the Borough Council and Minchinton in 1997, a court of appeal case where the claim was against the local authority. And there was a piece of land at the end of these people's garden, which was just being used as a compost heap and pulling up weeds and tidying and the likes. And the Court of Appeal said that in those circumstances, the land is not really suitable for anything else than the compost heap and pulling up weeds. And there'd been an older case, Red House Farms, Thorndon and Catchpole from 1977, which was a piece of marshland somewhere, I think it was in Suffolk, that was accessed just by a little bridge and was not really useful for anything else. But what Catchpole was claiming, that was shooting. They were shooting on this land. What they were shooting, they didn't make clear. But they were shooting on this land and they successfully claimed adverse possession. So it depends on what the land is of use for.
Mm-hmm.
So that was some of what the discussions around adverse possession were. Shall I tell you the decision?
Yes. What did they decide?
Well, the First Tier Tribunal decided that until 2018, when the flowers, or the wild flowers, were planted and likes, there wasn't enough for adverse possession. You have to claim adverse possession in registered land. You have to show 10 years adverse possession, and 2018 is not 10 years ago. But the Upper Tribunal said that was wrong. They said that any one of these acts on its own might not be enough for adverse possession, but you should look at them all together. The fact that you're mowing the lawns is probably not enough for adverse possession. The fact your children play on this land is probably enough. The fact you planted herbs and flowers on it. But when you look at everything together and also the layout of the land, it was enough. It doesn't matter that there was no fencing and so on, but that was enough for adverse possession. So they succeeded, the Dobsons, Dobson and Fleming, in their adverse possession claim, and it got into the press.
So why did it hit the press? What's so important about it?
Well, they were saying millionaire. It's only about, sort of succeeds. I think it's because it's just 1 metre by 2.3 metre piece of land and, is it really worth it? I mean, no one had even bothered about this since 1994. I don't think the number 27 even knew it was there. Land at all. And I say, if you looked at the layout, if you see the photos in the press and in the media, then anybody would have just assumed this is part of number 29. But why people have to litigate and go up to Upper Tribunal, I've not seen. It's early days to see if it's going to go to appeal. That's the kind of case that does. Yeah, like the Clapham and Arga case when late 2024 was over £300,000 in cost. And that got into the media as well. Neighbour disputes tend to be a bit like that.
Yeah.
But the other thing is that they didn't really discuss it too much, but a lot of people think that fencing is required and fencing isn't required. The fencing is very useful and very sort of strong factor if you have fenced. But if you haven't fenced, then it doesn't mean to say, depending on the circumstances, it can't be adverse possession. There's a case called Thorpe and Frank, which I was surprised wasn't discussed in the case from 2018 from York, a couple of 1960s semis, where they were claiming adverse possession and it succeeded even there was no fencing because it was subject to restrictive covenants. It had to be kept open plan. There couldn't be any fences. And do you remember Kirkman and the Bradshaw Pub Company? We did a podcast on last year where there was no, it was fenced on all around apart from where you access the lane, and they didn't put in a gate on because if they put a gate on, they wouldn't be able to access the building that they were claiming adverse possession over. So fencing's not the be-all and end-all. And no doubt we'll be doing another adverse possession case before too long.
Thank you very much, Richard.
Thanks, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.